The petitioner in the just-ended election petition, John Dramani Mahama, has expressed his disappointment in the Supreme Court's unanimous decision to dismiss his election petition. Reacting to his defeat, the former president intimated that his defeat came as no surprise, as the Appeals Court had denied many of the applications filed by his legal team. His response came a few hours after a 7-member panel of Supreme Court judges, in a unanimous decision, dismissed the election petition he filed to seek redress in what he described as fictionalized and fictitious elections. However, not finding any merit in his case, the Appeals Court dismissed it, describing it as without merit. Mr. Mahama's argument presented before the Appeals Court states that none of the candidates who contested the polls obtained more than 50% of the vote cast. He alleges that the person said to have won the polls benefited from vote pardon. He also claimed that the candidate benefited from arithmetic and computational errors. He concluded that the EC declaration of President Akufo-Addo is unconstitutional since he did not obtain more than 50% of the valid vote cast. Addressing the media, Mr. Mahama further stated that his quest to hold the chairperson of the Electoral Commission, Jean Mensa, accountable for the electoral anomalies were blocked by a protective cordon and firewall. He further disagreed with the opinion held by the Supreme Court that his petition was akin to any other civil litigation, as the EC chair, who is liable to account for her role in the election, evaded the law.
Earlier today, the Supreme Court of Ghana delivered its verdict on a petition we filed against the declaration made on the evening of the 9th December 2020 by the chairperson of the Electoral Commission of Ghana, Mrs. Jean Mensa, on the presidential elections of December 7th, 2020. My brothers and sisters, I did not take the decision to go to court lightly. In fact, many were those who expressed misgivings about my decision, not because we did not have a strong case, but because of the times we live in. I still believe that no matter the circumstances, it was the right thing to do. It is gratifying that the court proceedings were broadcast live and Ghanaians followed the hearings diligently. They understood what was happening, even if the legal terminologies were not always easy to grasp. Even though the petition to the Supreme Court stood in my name, it nonetheless represented the desire of an overwhelming number of Ghanaians, anxious for answers from the chairperson of the Electoral Commission as the returning officer of the December 2020 presidential elections. Ghanaians were hoping to hear her testify, and many are still baffled by the refusal of Mrs. Jean Mensa to be held to account by testifying in this case, unfortunately with the unanimous agreement of the justices of the Supreme Court. The vital part of the process to establish the truth and hold Mrs. Mensa accountable was blocked time and again by a protective cordon and firewall that I'm sure has confounded many Ghanaians. The refusal of this chairperson is in sharp contrast to the readiness with which Dr. Kwadwo Afarijan, then chairman of the Electoral Commission, willingly testified in the 2013 election petition filed by then candidate Nana Akufo-Addo of the MPP. Speaking as a Ghanaian with no legal training, I believe that the refusal of the Electoral Commission chairperson to testify in this election petition leaves a very bad precedent for the future. I disagree with the suggestions of our justices that an election petition is akin to any other civil litigation, and therefore an EC chairperson whose functions go to the heart of our democracy can, by a legal sleight of hand, avoid accounting for her stewardship in an appropriate forum such as the highest court of the land. Our legal team, led by Mr. Chachuchi Kata, put together our case in a clear manner, which left no one in doubt about the issues that were at stake. Apart from seeking to ensure compliance with the Constitution and for the true choice of the people of Ghana to be respected, the petition sought to provide opportunity for transparency and accountability in the management of our electoral process. But no one who followed the proceedings of the Supreme Court will be surprised with the judgment pronounced a few hours ago. Much as I'm aware that we are legally bound by the decision of the highest court of the land, the Supreme Court of Ghana, I disagree with the process of the trial and the ruling of the court. For the avoidance of that, I say, much as I'm aware that we are legally bound by the decisions of the Supreme Court, I disagree with the process of the trial and the ruling of the court. Ladies and gentlemen, our 1992 Constitution says very directly in Article 125, Section 1, that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. I believe that law should not be an instrument for partisan purposes. I also believe that the rule of law should mean one rule for all. What anchors the rule of law is equality and fairness to all, irrespective of creed, background, or political coloration. Justice, we must remember, is rooted in moral foundations. Ghanaians will always remember that moment when my lead counsel, Mr. Chachuchi Kata, quoted from the Holy Bible, urging the justices of the Supreme Court to be faithful to their judicial oath and their conscience, only for the lawyer representing the second respondent to argue for the exclusion of God in this matter. And yet in the courts of Ghana, including the Supreme Court, we swear on the Bible or the cross, as we also do with the Holy Quran, to speak the truth and nothing but the truth. Ghanaians will also remember, and this will go into history, this 2021 election petition for that profound moment when the chairperson of the Electoral Commission opted to evade public scrutiny. Everything was done in this trial to prevent the Commission from accounting to the people in whose name they hold office. Requests for interrogatories were dismissed. A request for inspection of documents in the possession of the Commission was turned down. The request for admission of facts was ignored. And worse still, she was aided by her counsel and the court to avoid explaining to the good people of Ghana from her own testimony under oath in a properly constituted court of law the errors that she herself admits to have committed in the declaration of the 2020 presidential election results. This is a clear stab in the heart of transparency and accountability to the sovereign people of Ghana. Whatever the reasons for not allowing Mrs. Jean Mensah to testify or answer any questions, it leaves an embarrassing stain not only on our justice delivery system, but also on our nation's electoral system, which has deepened the grave doubts harbored by many Ghanaians about the true outcome of the December 2020 presidential elections.